Matt Suing.
And Nels Donovan from Estate Law Partners.
Now, in part 2 of our video series on DIY estate planning, we continue to discuss some of the mistakes or unforeseen issues that could cost your family dearly.
Last time we talked about the importance of following experts and your state law.
Here are 4 more reasons why a DIY estate plan can lead to a false sense of security, as it may not achieve what you think it does.
To continue from our previous video, we're on reason number 3. A DIY estate plan could contain inaccurate, incomplete, or contradictory information.
You don't know what you don't know. For example, if you create a will using an online questionnaire, there's the possibility that you select the wrong option or leave out important information that could result in not accomplishing your goals.
In addition, some online tools provide lots of options without explanation. This could unknowingly contradict other parts of your estate plan.
Reason number 4, your DIY estate plan may not account for changing life circumstances.
For example, if you create a will in which you leave everything to 2 children, what happens if one of those children passes before you do? Will that child's share go entirely to their sibling, or will it go to the child's offspring?
What if one of your children accumulates a lot of debt? Is it okay with you if the money or property the indebted child inherits is vulnerable to claims of the child's creditors?
What if your will states that your daughter will receive the family home as her only inheritance, but it's sold shortly before you die? Will she inherit nothing?
An experienced estate planning attorney will help you think through the potential changes and contingencies that could have an impact on your goals and design a plan that prevents unintended results.
All right, now we're on reason number 5. Some of your assets may be left out of your estate plan. Even if you've created a DIY trust, if you do not fund it, which is a term of art basically describing connecting your things with your estate plan, an often overlooked step 2. Without completing this connection, your DIY trust will be ineffective, and your loved ones will still have to endure the probate process.
Regular meetings with an estate planning attorney can help ensure that any assets you acquire are not left out of your plan.
And finally, reason number 6. DIYers frequently make mistakes in executing the plan.
We'll cover this in depth in a future video, but there are certain requirements that must be met for wills and other estate planning documents to be legally valid, such as number of witnesses, whether you need a notary. This depends on what state you are in and what documents you are trying to sign.
Every once in a while I hear someone say, my spouse is a notary, they can do it.
Won't work.
What if I have one of my children act as my witness?
Not a good idea.
You know, it's part of our job to make sure that the documents that we prepare are legally effective. You don't hear this from DIY estate planning solutions.
Please contact us at estatelawpartners.com so you can be rest assured that all the I's are dotted and the T's are crossed.